Hello and welcome to our information session on healthy relationships. Thanks for joining us. I'd like to begin by sharing what's on the agenda for today's presentation. First, we're going to give a quick introduction to PLEAN and talk briefly about the project. We're then going to identify what abuse is and talk about some ways that we can identify those who may be experiencing violence. We'll then move into safety planning, which is something that we can use ourselves, or we can share with clients, friends, or family members who we may know are in unhealthy or abusive relationships. We'll then move into the various legal responses to violence and who a person can expect to encounter in the justice system. From there, we'll talk about the court process that victims can expect and talk about the Victim Services Program. And finally, we'll cover some frequently asked questions and talk about resources available right here in the province. So as I said, I'd like to just briefly introduce you to Public Legal Information Association of Newfoundland and Labrador, or PLEAN for short. We're a small, non-profit organization working to educate Newfoundlanders and Labradorians about the law. Our mandate is to increase access to justice, and we do so by providing legal information and education. Though many may not have heard of us, we've been around since 1984. We offer several services to fulfill our mandate, including a toll-free legal information line and lawyer referral service, community and school presentations and publications on a variety of topics, a website, a summer youth justice camp, as well as a variety of special projects. This project being one of them. This one is a 5-month project that's funded by the Law Foundation of Ontario. This project was born out of a recognition that our geography in Newfoundland and Labrador sometimes makes it difficult for individuals to access the legal information that they need. As we know, our province has a population that's widely spread out into small rural communities. Many of these communities lack access to the same information and services available in larger centres. The logical solution in our mind was to bring the information directly to the general public, which is why in July of this year we delivered several presentations to small rural communities across the Avalon Peninsula, and why we chose to add it to our website so people can access it from the comfort and privacy of their own home. Our hope is that this information will be useful to you, your friends, family, and colleagues and clients. We're now going to jump right into the presentation, and the first topic is on recognizing unhealthy relationships. There are some very real differences between a relationship that's healthy and one that's unhealthy. A healthy relationship is when two people develop a connection that's based on mutual respect, trust, honesty, support, good communication, and more. This all takes work. Each relationship is a combination of healthy and unhealthy characteristics, and this applies to all relationships: work, friendship, family, and romantic ones. At times, all of our relationships will have some unhealthy characteristics, but unhealthy relationships have these characteristics more frequently than healthy ones and cause undue stress. The tension is really unhealthy for both members. An unhealthy relationship might look like one person feeling pressured to change who they are, one person feeling worried or scared when they disagree with the other person, one person feeling pressured to quit activities or break their connections with family and friends, one person feeling forced or obligated to have sex, arguments that escalate into yelling or physical violence, that's a sign of an unhealthy relationship, unequal control of resources, meaning only one person can control the money or the car. There's many other examples. These are just a few. What is abuse? Well, a Department of Justice publication called Abuse is Wrong in Any Language defines abuse as behavior that's used to intimidate, isolate, dominate, or control another person. It may be a pattern of behavior or a single incident. And this really falls in line with all definitions of abuse that I've found, which all state that abuse is really about an imbalance of power, with, of course, the abuser having power over the victim in some way. There are many forms of abuse, including physical, sexual, psychological, emotional, financial, verbal, spiritual, and neglect. Many forms of abuse can result in criminal code charges, and we're going to talk in more detail about that later. Now we want to talk about who a victim is. And the fact is, anyone can be a victim. A victim is anyone who has suffered harm or loss, or who has been threatened. Victims can be any age, any gender, any race, and be of any economic or social status. Statistics do show that women are at a higher risk of sexual assault, stalking, serious spousal assaults, and spousal homicide than men are. Research also shows that some people are at a greater risk of experiencing any type of abuse, and these groups include young women, Aboriginal women, women isolated in the home, perhaps because they live in a rural community, women who are pregnant or have young children, women in common law relationships, those who are recently separated, persons with a disability, and elderly persons. You'll notice that we chose a picture of a group of smiling, happy people for this slide. That's because we want you to think a little differently of how we imagine a victim. Victims don't often look like victims. They aren't necessarily bruised. They aren't necessarily visibly upset. They may not even seem to suffer from low self-esteem. Many victims have gotten very, very skilled at hiding their realities from the public, and sometimes even their closest family and friends don't know what's going on. It's important for us to keep an open mind when considering whether or not your loved one might be experiencing abuse. To reiterate, while some groups of people may be more likely to be victimized, the reality is that any one of us can be a victim of violence. And regardless of what may trigger that violence or what was said to ignite an argument, victims are never to blame for the abuse. It's important for us to recognize the warning signs that someone is a victim of abuse, and there are many of them. They may include a person might apologize or make excuses for the abusive behavior that's happening to them. They may have no friends, no family, and no access to a phone. They may be nervous talking when their abuser is present. They might try to cover up bruises or other signs of abuse. They may fear for their safety, their children's safety, or even their lives. They may make excuses to avoid seeing you. They might be in denial and not able to see their risk. They might blame themselves for the violent behavior, and they might walk on eggshells. They might seem sad, lonely, withdrawn, and afraid. They may be sick and frequently miss work and school. They might be defensive and angry, and they may cope by using drugs or alcohol. Now, certainly, not all victims will display all signs, but it's important for us to be cognizant and to reach out to those who may be displaying any warning signs of victimization. We're now going to look at the next phase, and that is deciding to leave an unhealthy relationship. If you're in an abusive relationship, you may want to consider creating a safety plan. This is a plan that will allow you to leave the abusive relationship quickly, particularly in the event of emergency. If you must act quickly, it's important to be prepared. When making your plan, you should ask yourself the following questions. Where will you go in an emergency? You're going to need to go somewhere safe. How will you get there? Do you have someone that you can call to pick you up and get you, or will you need money for a taxi or a bus? Perhaps you can drive yourself. Is there someone that you can call and tell what's happening and tell them where you're going? Do you have pets? Is there someone you can leave them with? If you need to go to a shelter, do you know how to get there? Once you have answered these questions, then you're ready to create your emergency plan. Some steps might include establishing an escape route, knowing a safe place that you can go and make a phone call. It might also include having emergency phone numbers ready, whether that's programmed into your phone, in your address book. Use pretend names if necessary, if you need to disguise the name of the shelter or the police. Speak to your neighbors and people you can trust if possible. Let them know what's happening so that they can be watching for you and can call the police if they become concerned. Call a transition house or shelter and talk to the staff. It may be possible for you to establish a code word so that you can call and identify yourself in the presence of your abuser if necessary. It's important to note that in Newfoundland and Labrador, shelters are options for women only. Hide away some money if possible, for a taxi, and a spare set of car keys to leave quickly if possible. And consider getting some legal advice. The Department of Advanced Education and Skills provides support to those leaving a violent relationship. Emergency supports for victims of violence include transportation to a shelter or transition house or other safe location, accommodations, a personal allowance for the period of time that you reside at the shelter. This is based on financial circumstances. There are also supports for victims of violence who are in receipt of income support, and those benefits include continuation of income support benefits based on your financial circumstances. Transportation may be provided to you to move from one shelter to another for safety reasons, to move household furniture, to get supportive counseling, or to move outside the province for safety reasons. A startup allowance as a contribution towards obtaining furniture, linens, and clothing, etc. may also be available if it's determined to be unsafe to return home for those items. And the services of a regional liaison social worker is also available. If you'd like more information, you can call 1-877-729-7888. That includes after hours. Consider packing an emergency bag with essential items, enough to last you for a few days. Leave the bag with a friend if you can, or some other safe place. Some items that you might want to consider packing include money, bank cards, credit cards, including quarters for a payphone. Purchase some prepaid phone cards as well if you can. Clothing for a few days, any medication you may need, your keys for your house and your car, identification and your passport, your important papers such as your birth certificate, your marriage certificate, your social insurance number, perhaps your income tax returns, MCP card and any health or insurance cards, your First Nations status card if applicable, immigration or citizenship papers if applicable, copies of your lease or deed, your address and phone book, your driver's license, your car registration and insurance, and your favorite possessions or books or photos, some things that may give you comfort during this time. Some people think that taking such things as your tax returns or the deed to your home might be overkill, but keep in mind it may be a fresh start for you if you leave, and returning for these documents might be unnecessary, difficult, or just impossible. We're now going to move into the justice system side of things and look at the options that are available to those who plan to leave an unhealthy or abusive relationship. The first legal option we'll discuss is the Emergency Protection Order, or EPO. An EPO is a provincial court-ordered document which a judge can grant quickly, usually within 24 hours in urgent family violence situations. It does not replace a criminal charge. Police can still lay charges under the criminal code. In order to be eligible to apply for an EPO, the person must live or have lived with the respondent in a conjugal relationship regardless of their marital status. This applies to heterosexual and same-sex couples. Or the person must have a child or children with the respondent, regardless of whether they currently live or have ever lived together. So, if the applicant and the respondent have a child or children together, they need never have lived together for the person to be eligible to apply. A child or youth cannot apply for an EPO, and elderly parents cannot apply for one against their children, etc. People can only apply for one against an intimate partner or the parent of their children. In order to get an EPO, an application must be made. The police can apply for an EPO 24 hours a day with your consent to do so. The judge then will normally decide whether to grant an EPO within 24 hours of receiving an application. The police do not need to apply for the EPO. A person can apply themselves or have a lawyer do it for them. However, if that option is chosen, it can only be done during regular court hours. Only the police can apply for an EPO 24 hours a day. An EPO can last for a maximum of 90 days. As each case is unique, the judge will decide how long each EPO should last for within the 90-day time limit. So, an EPO could last for less than 90 days. An EPO is not a criminal conviction, so it will not result in a criminal record. However, it is an offense to violate an EPO, and that is punishable. Finally, it's important to remember that an EPO is a short-term emergency response. It's meant to offer an immediate response and to provide time for longer-term plans to be put in place. As such, an EPO cannot be extended or renewed. Note that if a judge says no to an EPO application, an applicant cannot appeal it. The respondent, however, does have the right to appeal it if there is one put in place. We're now going to move on to the second legal response to violence, which is the peace bond. Peace bonds are set out in Section 810 of the Criminal Code. It's an attempt to ensure that no harm comes to an applicant, or their families, or their property. A peace bond is a court order that places specified conditions on an individual's behavior. Conditions may include to keep the peace, not to communicate with the applicant in any manner, not to carry a firearm, and the judge can impose other conditions. These are just a few examples. Just like an EPO, a peace bond is not a criminal charge. Anybody can apply for a peace bond if they fear for their safety or their family's safety, or they fear damage to their property. Youth can apply for peace bonds as well as adults, and a youth is someone aged 12 to 17. There are two types of applications. One made because you fear another person may injure you or your family, or one made because you fear another person may damage your property. A person can apply for a peace bond by submitting an application to provincial court. Depending on where you're located in the province, Victim Services or RCMP or RNC offices may also have these applications available. The form must be completed and sworn to before a justice of the peace. Once an application is filled out and provided to the court, a summons must be served on the person named in your application. That person must appear in court on the date and time specified in the summons. You must also appear in court at that date. At that time, if the person named does not agree to the terms of a peace bond, then the matter will be scheduled for a hearing at a later date. At that hearing, you will testify, as well as your subpoenaed witnesses. Make sure that you bring any evidence you have which will support your case. The accused and his or her witnesses will also have an opportunity to testify. The judge will decide, based on the evidence, whether a peace bond should be put in place. There is no fee for applying for a peace bond, and the order can be valid for up to 12 months. As I said, a peace bond can be valid for up to 12 months, but if a person still fears for their safety after that period, they can reapply. There's no fee to apply for a peace bond. If a person breaks a peace bond, they may be charged with a crime under the criminal code. If that charge is proven, punishment may include jail time. Peace bonds are not for emergency situations. Because court schedules are often fully booked, it may take weeks or even months to process peace bond applications. It's very important for people to remain vigilant and safe, as peace bonds are not implemented with the speed of an EPO and are not meant to be an emergency measure. So, to give an overview, peace bonds are federal, whereas EPOs are provincial. Peace bonds last up to 12 months and can be extended, whereas EPOs last up to 90 days and cannot be extended. Whereas peace bonds might take weeks or months to implement, EPOs are treated as emergency measures and implemented quickly, usually within 24 hours. A peace bond is not an emergency measure and is not suitable for emergency or dangerous situations. EPOs are meant to provide a quick response in case of emergency for victims to put longer-term plans in place. Peace bonds are broader and include a peace bond against personal injury or property damage. EPOs are limited to family violence, and people can only apply for EPOs against people who they're in a conjugal relationship with or people whom they have children with. EPOs are geared toward domestic violence. We'll now talk about the third legal response to violence, and that's the laying of criminal charges. The process of laying a charge begins with the police. The police will begin an investigation if they receive information or observe behavior that warrants an investigation. An investigation may be completed very quickly, but it may take weeks, months, or even years, depending on the complexity of the situation. If there's enough evidence, police will lay a charge. A suspect may be arrested or may be notified to appear in court at a later date. The decision to lay a charge is the responsibility of the police and not an individual, as people often think. The police will lay a charge if, based on reasonable grounds, they believe a person has committed a crime. They don't need absolute proof of guilt to make an arrest, but they must have more than just a suspicion. Now, while it is the police who decide whether to lay the charge, it's up to the Crown Attorney to decide whether that charge will actually proceed to court. The Crown Attorney will ask two questions when deciding whether to proceed to court with a charge. Is there a realistic prospect of conviction, and is it in the public interest to proceed? If the answer to both questions is yes, then the Crown will prosecute. If the answer to either or both of the questions is no, the Crown will not prosecute. Many forms of abuse are actually criminal charges, as we spoke about earlier. If you're interested, the Criminal Code can be found in full online at the Federal Department of Justice website. We'll highlight some of the possible criminal code charges that can result from various forms of abuse. It includes assault and assault with a weapon. Assault happens when a person directly or indirectly intentionally applies force to another person or attempts or threatens to do that. This can include a broad range of physical contact, including hitting, punching, slapping, pushing, biting, kicking, spitting, and more. If a weapon is used during an assault, then the charge would be assault with a weapon. It's important to note that a weapon can be anything that's used for the purpose of harming or threatening another person. We often tend to think only of items that are meant to be weapons, like knives and guns, but anything can be a weapon if it's used as one. So a book, a baseball bat, a coffee mug, etc. Uttering threats occurs when a person threatens bodily harm or death to any person, their pet, or threatens to damage their property. Sexual assault is sexual contact with another person without their consent. The type of charge, whether it's sexual assault with a weapon and/or causing bodily harm, or aggravated sexual assault, will depend on the specific occurrences in the situation. Making indecent or harassing phone calls. A person can be charged with making an indecent call if they make an indecent call with the intent to alarm, annoy, or harass a person. A person can be charged with making harassing calls if he or she makes or causes to be made repeated phone calls to that person with the intent to harass and does so without a lawful excuse. Criminal harassment or stalking is harassing behavior that gives a person good reason to fear for their personal safety and has no legitimate purpose. It's generally repeated, but a single incident, if it's overtly threatening, might be considered stalking. It's important to remember that some people do have lawful reason to repeatedly contact you. For example, a debt collector may call several times, and while a person might not like it, it is lawful as long as it's done according to the laws that regulate collections. And finally, homicide, which is the killing of one person by another. Next, we're going to talk about some sentences, because often people are curious to know what sorts of sentences their offenders may have to face. An absolute discharge is when the accused is found guilty by the judge, but there is no official conviction and no criminal record. This is the lightest sentence available and is usually only used for a less serious first-time offense. The accused is free to leave after the sentence is imposed without any conditions or restrictions. A conditional discharge is when the accused is found guilty, but there is no official conviction. However, the accused is ordered to obey certain conditions set out in their probation order for a specific period of time. If the conditions aren't followed, then the person can be convicted of the original offense and sentenced accordingly. But if the offender obeys the conditions, then he or she will have no criminal record. It's important to note that absolute and conditional discharges are rarely, if ever, used in cases of family violence. A fine, of course, is a sentence whereby a convicted person is ordered to pay a specific amount of money as punishment. The fine is paid to the court and not to another individual, and usually has to be paid within a specific amount of time. Restitution is when the court may order the offender to pay financial costs directly associated with the offense to a victim. Probation is a set of conditions that can allow an offender to serve their sentence in the community as long as they obey the specified conditions. Conditions might include keeping the peace, attending school, meeting a curfew, refraining from unlawful behavior, etc. If an offender fails to follow these conditions, they can be charged for failing to follow the terms of the court order. A conditional sentence is commonly referred to as house arrest. This is considered a form of imprisonment by the justice system, but rather than going to jail, the accused is allowed to serve their sentence in the community as long as they follow certain conditions. Normally, the accused has to stay within his or her own home, except for specifically named exceptions. If the accused doesn't follow these conditions, they may have to serve the remainder of their sentence in prison. Jail is, of course, when the offender is sent to prison. An intermittent sentence is when a person has been sentenced to a jail term of less than 90 days, and the judge might allow them to schedule their jail time around work commitments. For example, some offenders will serve their jail terms on the weekends. Intermittent sentences are not automatic. The judge has to be convinced that this type of sentence is appropriate. And finally, a victim fine surcharge is something that's imposed in addition to any other punishment for a convicted offender. The victim surcharge is 15% of any fine imposed, and where there's no fine imposed, the fee is between $50 and $100. We're now going to discuss what a victim or witness can expect when going through the court process. We'll take a look at some of the people that a person could expect to encounter in the justice system. You'll notice that I have a screenshot of a website shown. The website, which is www.courtprep.ca, is a really helpful resource which includes, among other things, this helpful layout of a courtroom. It's a really good resource for victims. Of course, this layout is just a guide, and the courtroom in your area may be laid out differently. This, though, will give you a general understanding of what to expect. There are many people in the court system who you can expect to encounter. The first is the Crown Attorney, and this is the lawyer working on behalf of the government, on behalf of all members of society. That's because in Canada, crimes are seen as being a wrong committed against society. The Crown is required to prosecute cases fairly and treat all parties in the case, including the accused person, in a fair manner. Once the police lay a charge, as I said earlier, the Crown Attorney is the person that decides whether the charge will proceed to court and is the only person who can decide whether to drop or withdraw charges. The defense attorney or legal aid lawyer represents the accused person in a criminal trial. This lawyer represents the best interests of the accused and advocates on his or her behalf. The judge is the person with the authority to hear and decide criminal cases. The judge is the person that decides which punishment will be imposed, regardless of whether the person was found guilty by a judge or by a jury. People are sometimes unsure of how to address a judge in court, and the proper way to address a judge in provincial court is simply Your Honor. In Supreme Court, it's Justice or My Lord or My Lady. However, it is perfectly fine to refer to the judge as Sir or Madam. The court clerk is the staff member who announces when the judge appears in the courtroom. Before a person can testify, the court clerk will ask the witness's name, address, and ask the witness to take an oath to tell the truth. The clerk will also check to ensure that all audio equipment is functioning and may handle documents and evidence which are presented in court. The sheriff's officer is the person responsible for escorting prisoners as well as maintaining court security in some courts in the province. In some regions, the local police will act as prisoner escorts instead. A witness is a person who testifies in court because they have seen or have some information about a case. A witness is normally subpoenaed to court. If a victim testifies, then he or she is also considered a witness. And victim services professionals will likely be next to the victim as a support person in court. We'll talk more about the victim services program in detail in the next couple of slides. In terms of court support, however, victim services can provide a support person during the court process, can help explain and prepare for court, and can help with preparing a victim impact statement. We're now going to look at the court process, because many times victims are entirely unsure of what to expect in court. If a person is called to testify in court, it means that they're giving a statement to the court under oath. If a person has been the victim of a criminal offense, then the trial will be conducted in criminal court. Unlike family or civil court, criminal court is normally open to the public. This can be very difficult for many victims and witnesses because they feel that strangers should not be privy to their private business. The reason for this is that, again, in Canada, crimes are seen as offenses against society, and a public trial helps ensure the justice system is open and transparent so that people can see that justice is being properly served. So even though sometimes it feels like an invasion of privacy, it's actually a charter right for a person to have a public trial. If you've been subpoenaed to court, it's very important that you attend. You can have a warrant issued for your arrest if you're absent. You could be arrested by police, held in jail until you appear in court to testify. If you forget to mention something to the police during your statement, it's important to contact the police and let them know immediately. Don't wait until the day of the trial to introduce new information. The accused person has the right to know the case against him or her and to have the opportunity to review all of the information which is being used against them in the case. If the evidence isn't supplied to them in a timely manner, it can result in postponement or the charges might even get thrown out. Finally, the chart that you see on your screen explaining the criminal court process is available in a publication of ours called Family Violence Getting Help, which is available on our website. As I said earlier, we have a little more information for you about the Victim Services Program. It's a voluntary program that's offered through the Department of Justice. It responds to the needs of victims of all ages, and their services are completely free of charge. It's professionally staffed, meaning there are no volunteers. There are programs for both adults and children, and their website is particularly useful with many useful resources, including videos. Clients can be self-referred to the program, or they may be referred from any number of professionals or community organizations, including the police, Crown Attorney, doctors, etc. The aim of victim services is simply to provide information to clients and to allow them in turn to make their own decisions. You can get much more information by visiting their website, which is www.victimserviceshelps.com. A victim of crime is entitled to prepare a written statement which will be read by the judge, the Crown Attorney, and the defense counsel if the accused is found guilty. The statement tells the court about the harm that the victim suffered because of the crime committed against them. Sometimes these are read aloud in court, which can have a very strong impact on the courtroom. Once again, this is something that victim services can help a victim prepare. We're now going to move into the final section, which is some frequently asked questions. Question 1. How will I know when my boyfriend will get out of jail? There are workers that are called victim liaison officers who work within prisons and can provide victims of crime with information about offender release dates. Again, your local victim services office will have more information on this program. The next question is, I'm very nervous about court. How do I act and what do I do? It's normal to be nervous. Even experts sometimes get nervous before testifying. Once again, if you'd like support, you can contact Victim Services, who can help explain the court process and even attend court with you if you like. In terms of how to act, simply acting mannerly and respectfully at court is all you need to do. It's important to be well groomed, but that doesn't mean that you need to dress up in a suit. Simply dress conservatively, don't chew gum, don't take food or drink into court, and be sure that your cell phone is shut off. If you start to cry, that's okay. In fact, most witness stands have a box of tissues. If you need a moment to compose yourself, it's perfectly fine to ask the judge to take a break. You might find it helpful to practice some relaxation exercises before court, such as concentrating on breathing slowly and deeply. It may also be helpful to bring a support person. You can talk to the support person, but remember that you can't talk about the evidence that you'll give in court. If someone suggests to you that you might relax with a glass of wine, this is not a good idea. If the judge, lawyers, or police suspect a witness has been drinking, they may halt proceedings or even throw out the charges. The judge may even decide to hold you in jail until you're able to testify properly. The next question is, what do I do if I don't understand the lawyers? And if you don't understand a question, be sure to tell the judge. The lawyer might have to rephrase, or the judge may explain it further. Don't be embarrassed. Legal jargon is exceptionally difficult for most people to understand. If a lawyer says objection while you're talking, simply stop talking. The judge will indicate when it's okay for you to speak again. The next question is, what are testimonial aids? The Criminal Code allows for special considerations when witnesses give testimony. Testimonial aids are sometimes used for victims and witnesses who are younger than 18 years of age, or anybody that has a disability which may make communication difficult. Some examples of testimonial aids might include testifying behind a screen, testifying outside the courtroom via closed-circuit television, or testifying with a support person. Testimonial aids may also be granted to people who are over 18 but don't have a disability, at the discretion of the judge. The goal is to get a full, candid, honest testimony, and testimonial aids are designed with that in mind. The next question is, what is the Family Violence Protection Act? It's a piece of provincial legislation that became law in 2006. It provides for a broader range of more immediate responses than the Criminal Code. It's important to note that all criminal justice responses will remain in place. The Act just provides more, specifically emergency protection orders. And the Act does not intend to decriminalize family violence. What is the duty to report? In Newfoundland and Labrador, everybody is responsible for reporting child abuse, and child abuse is physical harm, emotional harm, sexual harm, or living with violence and being left without adequate supervision. In Newfoundland and Labrador, it's everyone's responsibility to report this. If you suspect that a child has been abused, or if a child tells you that he or she has been abused, it is the law to immediately report it. You can report it by contacting your local regional health authority or police. There is also a duty to report the neglect of an adult, as set out in the Neglected Adults Welfare Act. A new act called the Adult Protection Act, which should come into effect next year, will have a similar duty to report for all forms of abuse, not just neglect. The next question is, my girlfriend and I have made up, can I have the charges dropped? A victim cannot drop charges, though that is a common misconception. It is solely the decision of the Crown Attorney. If a victim would like to see charges dropped, they should contact the Crown Attorney and make their wishes known, but the Crown will decide based on their own criteria. The Crown will not automatically drop charges simply because a victim wants them dropped. It's rarely done in cases of domestic violence or in child abuse because the cycle of violence is so prevalent. Similarly, to vary a court order, the Crown would need to agree to the variation. If they don't agree, the accused who is on the order would likely have to apply to the judge, and the judge would decide whether to vary it or not. Finally, the last question is, what is a publication ban? In some criminal trials, including those involving children or sexual offenses, the judge may make an order which prevents the identification of the victim outside of the courtroom, so on television, on radio, or in newspapers. Publication bans are made to prevent the unnecessary publicity of a victim of an offense. There are many resources available here in our province. There's more information on resources in the Getting Help pamphlet, which is in the same section of the website that you found this webinar. Some resources that are available in the province, as I already discussed, is Victim Services, our office here at Plian. There's a national office for victims. Provincially, there's a sexual assault crisis line and a mental health crisis line. Provincially as well, the Legal Aid Commission, the Violence Prevention Initiative, and the Transition House Association of Newfoundland and Labrador are all excellent resources. If there are any questions on any topics covered today or any other legal topics, we encourage you to please contact our office. We're located at Suite 227 on 31 Peet Street in St. John's, and you can reach us by phoning 709-722-2643 or toll-free at 1-888-660-7788. You can visit our website, www.publiclegalinfo.com, for more information. And you can also email us, info@publiclegalinfo.com. Thank you so much, and have a great day.